I love every HelloFresh dinner, and it's really hard to pick a favorite. But this week, I made a wonderful sort of home-style chicken and biscuit pot pie. And it was like so wonderful in the cold and winter of Chicago. And that's just one of the delicious meals I've tried through HelloFresh. We know you'll love it too. With over 50 menu and market items to choose from every week, you'll never get bored. Get 16 free meals plus 3 gifts with code SISTERS16 at hellofresh.com/sisters16.
Welcome back to Hashtag Sisters-in-Law with Kimberly Atkins Storr, Jill Wine-Banks, Joyce Vance, and me, Barb McQuaid. We're excited to announce that we have a brand new item in our Hashtag Sisters-in-Law merch store. It is a women's tee. Go to politicon.com/merch and get yours now before they sell out. Today, we will be discussing the judge's dismissal of Sarah Palin's lawsuit against the New York Times, Donald Trump being ordered to sit for a deposition in the civil fraud investigation by the Attorney General, and the motion filed by John Durham with more allegations about Hillary Clinton's campaign. Again. And as always, we look forward to answering your questions at the end of the show. It was a big news week, a heavy news week, and I want to get some advice from my sisters about something that is much lighter. I find sometimes when I am up on a weekend morning early, it's Sunday morning, I kind of want to do some work like, tidying up of emails and that sort of thing that doesn't require much heavy lifting. And I'm looking for some lighter music to listen to. The stuff I tend to listen to, I realized recently, is rather dated. So, it's music I refer to as kind of Sunday morning groove. And so for me, that's Tracy Chapman, maybe Norah Jones, maybe Sean Colvin. And it occurred to me I really need to update my repertoire, or if nothing else, at least broaden my repertoire. I wondered if you guys have any suggestions, or maybe the kind of music you like to listen to when you're kind of, just being chill and is kind of in the background, but it allows you to work. You have anything that you found that is a good Sunday morning groove?
Barb, I don't know. You're saying that you listen to music that seems dated. When I look at my playlist, they're the same as they were 15 years ago. So I cannot say that I've
although the 90s, I'll point out, is 30 years ago. But go on.
Okay, there's some of that on there too. But just listening to you talk about this, I'm reminded that one of my former single person behaviors was I would get up on Sundays, I'd grab the newspaper, I'd make myself some eggs, and in my kitchen in my old apartment, there I had like stools that go up to the kitchen counter, and I would sit there, read the paper, listen to Sade, and it was the most soothing, nice, easy way to ease into a Sunday. And I really enjoyed doing it. Sometimes it would, I would vary a little bit, and I might pick Joan Armatrading or something, but it was just a gentle, nice way to start my Sunday. And I realize I don't do that anymore, and I should bring that behavior back. I know my husband also likes
smooth operator. Yeah, that's the kind of
smooth
thing.
Operator is good. My husband likes things like Sinatra or old big band. It still does the job, but I think that's a great idea for a Sunday morning. What about you, Joyce?
Yeah.
Two things that I used to do to decide what music I wanted to listen to are less available. One was I would sit in coffee shops and I would use the Shazam app on my phone. If there was a song that was playing in the background, I thought, oh, that's a song that I like, I would add it into my playlist. And of course, I don't sit in coffee shops right now, so I don't do that. And then my 2 youngest kids, who were both off, one at school, one doing a fellowship year, I used to pick up their music. My daughter listened to exactly the kind of music that you're describing, Barb, sort of what we used to listen to in the 90s. She would listen to the 20-something version of that, so she kept me current. But my son did something that was even much more fun for me. He loves rap, so he turned me on to musicians like Lil Nas X and music like that I incorporated into my playlist. playlists. I sort of miss their influence, but I tend to be all over the board. And something I've been doing for the last month or so is listening to show tunes. I've gone back to listening to the soundtrack from Hamilton and Dear Evan Hansen, and I really like that music on a Sunday morning.
Oh, that's good. I love the image of Joyce, belting it out while she's knitting in a quiet Sunday morning. That's excellent.
To Old
How about
Town
you, Jill?
Road.
You gotta... or rapping.
And Springsteen, right?
Or rapping,
Always Springsteen.
How about you, Jill? Are you a rapper or a show tune gal?
I'm very eclectic in my musical taste. I'm sort of with Greg because I love Frank Sinatra. My husband's and my favorite song is Strangers in the Night by Frank Sinatra. But we also love Diana Krall.
Oh, yeah,
who
that's a good
is
one.
A fabulous, she's really good for a Sunday
Also
morning.
from the 90s, I imagine.
I would have to say, if you think dated, my playlist is really dated because I loved 50s and 60s music, and I've never outgrown it. But I love Ella Fitzgerald, who I think is timeless. And I did appear once on The Beat with Ari Melber with Royce da 5'9". And so I did some real research on his music. I found that I had a Jill's pin because he had a song called Caterpillar, and I actually had a Caterpillar pin. But so it sort of brought me into his music. And he was delightful and charming, and he was just fun to be with. So I listened to sort of a very wild thing when I'm in my car listening to things. The CDs that I keep in my car, the one I play the most is opera. And Lakme is a very little-known opera, and I listen to that constantly, and it is perfect for a Sunday morning. It's just beautiful, beautiful, soothing music.
Hey, Barb.
Sad
Will you
story,
send
of
us a
course.
link, Jill? I love opera, and I don't know that one. I'd love to listen to it.
Oh, I will.
I think
definitely.
we need a Sisters-in-Law Sunday morning groove playlist.
I think that's a great idea.
Maybe our
That's a
listeners,
great idea.
maybe our listeners could make some suggestions about what we should be listening to on a Sunday morning, and we can curate our own list based on our own taste and maybe some submissions from our listeners. How about that? Listeners, give me something good to listen to on a Sunday morning.
And I will leave us with just one more. Remind when Joyce said that her kids would give her things. My stepson has my husband and I listening to Yola, who, based on your taste, Barb, I think you might like. So that's a place to start. Yola.
All right.
She's a really great singer, and our 20-year-old my 20-year-old stepson, my husband's 20-year-old son, is keeping us hip.
All right, I will check out Yola, and then I can have something later than the 90s that I can tell people I'm listening to. All right, well, let's get to it.
Our first topic today is about Sarah Palin and the judge's dismissal of her lawsuit. She's, of course, the former governor of Alaska and the former vice presidential candidate who couldn't name any newspaper she read and said she was qualified because she could see Russia from her house. She certainly qualifies as a public figure. So when the New York Times incorrectly claimed a link between Palin and the 2011 mass shooting in Arizona that severely injured U.S. Representative Gabby Giffords, killed 6 and injured 13, she sued for libel despite the Times quickly publishing a correction saying there was no such link established and apologizing. She said her reputation was injured and claimed unspecified damages. This week she had a double loss in a New York federal court. First, the U.S. District Court Judge Jed Rakoff for the Southern District announced he would dismiss Palin's case regardless of how the jury ruled, and he did it while they were actually deliberating. So he let the jury take the case, and then he said, I'm going to dismiss it no matter what they said. But then she lost a second time because the jury ruled against her. So I want to ask some questions about this, but first, because people on Twitter are confused about what defamation is, I just wanted to say that it is generally how you get civil remedies when someone's words cause you harm to your reputation or livelihood. Libel is a form of defamation in writing or published, and slander is defamation that is spoken. So let me start with you, Barb, first, because, of course, she was ruled by the case from 1964, New York Times v. Sullivan, which set a standard about what evidence is necessary if you're a public figure in order to get compensation from someone who you say hurts your reputation. Does it, being opinion instead of news, because this defamation happened in an opinion piece, does that make a difference, and what is the standard?
Yeah, so as you correctly note, Jill, the New York Times versus Sullivan is the landmark Supreme Court case that said when the matter involves a public official or a public figure, then it's not enough to show that what they wrote was false. You have to show that they did so with a standard they described as actual malice. And actual malice means either that the publisher knew that the statement was false, or that they acted with reckless disregard as to whether it was false. And the reason that the standard is so heightened in that context is that the First Amendment is designed to promote freedom of the press and free speech. And we want to encourage the press to write about, even critically, about public officials. And so that might mean that from time to time, they get things wrong. And we tolerate that. It's okay. It's not great, and it's not great for the business reputation of any publication to get facts wrong. But in terms of whether that makes them responsible for civil damages, it is only true if they can meet that heightened standard of either knowing that it was false or acting in reckless disregard as to falsity. Now, your question is whether it matters that it's opinion or straight news. Certainly, people are entitled to their own opinions. And if the opinion simply said, Sarah Palin is bad, we believe she is bad, whatever it is, that's someone's opinion, and you can't claim defamation for that. But what happens so often in these opinion pieces is they state facts and then use that to base an opinion. And so in this one, it did include this false allegation about a link between her campaign and this shooting incident. So that could properly be the basis for that. But what the judge found here is that she failed to show that the New York Times acted with that level of actual malice that is required. I'll also note you also have to show damages. That is, not only that the person made this false statement and did so with actual malice, but that it genuinely harmed your reputation. And so if they retracted it within a couple of days, it's difficult, I think, for her to show that it in any way damaged her reputation.
I used to do this kind of work in private practice, and we used to talk about libel-proof plaintiffs. Sarah Palin, for the reasons Jill, laid out in opening, is just the poster child. If you look up in the dictionary, libel-proof plaintiff, it's Sarah Palin.
We should talk about it a little bit more after we get through some of the basic facts about why she is libel-proof. And I actually left out some of the most damaging things for her, but we'll talk about that later. Let me first go to Kim, who is our resident journalist as well as lawyer, and ask from a standpoint of a journalist, how important is the protection of New York Times v. Sullivan? Why do we care?
Yeah, it's really important because this case arose out of a tradition, unfortunately, by public officials, public figures, people who are famous. Donald Trump, even before he became president, was a public figure because he was famous. He put himself out in the public. He held himself out in a way that, of course, invites comment, that invites criticism. And so that even then, he would have been considered a public figure for the purpose of this heightened standard. And what would happen with Trump and others, but particularly before this New York Times v. Sullivan precedent was established, was that these folks would bully the press with threats of lawsuits or actual lawsuits that would beleaguer newspapers and other publications and whether it's radio, print, or broadcast, with the prospect of high legal fees or actual high legal fees in a way to basically bully them to keep them from covering them. And that is antithetical to the First Amendment. So there had to be a standard for the letter and the spirit of the First Amendment to be met that says, look, we are not going to provide a vehicle through libel laws for people to essentially suppress the press. If you are harmed in a real and meaningful way, yes, you should be able to seek redress. But if the newspaper makes a mistake, for example, and they print a retraction or a correction and they set the record straight, well, that's not really harming you. But there's no reason for you then to turn around and ask for a multi-million-dollar judgment and use this punitively. And we're going to talk, this matters in the Sarah Palin case as well for reasons we're going to talk about a little later, but it still happens today. We saw the way that Donald Trump threatened lawsuits against everyone. He campaigned on quote unquote opening up the libel laws in a way to make it easier to sue the press. He called the press the enemy of the people. So standards like this really are important that allow journalists, particularly those at smaller publications. I work at the Boston Globe. We have lawyers. We can defend against a libel case if one is if someone files one. But a lot of smaller news publications, they would be terrified of that. They do not have the money to pay for lawyers, let alone potentially pay a judgment. So it's really important to have that protection.
So that is important. But Joyce, before we get to some of these other pending issues, the judge here did something unusual because he announced he would throw the case out, and he did it after he let the case go to the jury, saying that basically if the jury ruled in her favor, he was going to overturn it and let the appellate court have the benefit of their verdict. And I know many of our questioners want this answered because we got at least 2 questions about this, one from Susan in Ardmore, Pennsylvania, and one from Kelly Banish. And so I want to talk about what the grounds were for his decision to dismiss the complaint, and what did he mean when he said that the jury decided on the facts and he on the law, and talk about whether it's unusual for a judge to take a case from the jury, and especially after they're deliberating.
Yeah, so actually in a libel case where, as Barb explained, the plaintiff has to prove actual malice, the Supreme Court has actually contemplated that there will be cases where the judge might make this finding against the plaintiff as a matter of law. And here's what that means. In our trial system, juries are the judge of the facts and judges are the judge of the law. And so, judges call the balls and the strikes in trial and decide what evidence comes in. But they also have an additional role, and this is the role that the judge played in this case. He determined that as a matter of law, there was simply insufficient evidence for the jury to find that actual malice existed. And so he made that finding. And that's actually okay. What's a little bit odd in this case is the timing. And I think that that's, where you're headed here. As you pointed out, Jill, the judge's reason was a good one. It's important for him to make his ruling if he believes that that's the correct ruling, but he acknowledged, I'm not perfect. I'm a judge. I'm not God. And in the event that a court on appeal should reverse me, it's important that we have a jury verdict so that there wouldn't have to be a second trial. If the judge's legal ruling on the law gets reversed, then the Court of Appeals would have a jury verdict sitting there, and they could insert that as the outcome of the trial without going to the time and expense of a second trial. The problem here is obviously that the judge has a jury that isn't sequestered. He makes his decision, and then he announces it while the jury is deliberating. And you don't have to be a rocket scientist to figure out that that would leak into the proceedings and possibly gum up the works down the road.
So before we get to that question, Barb, I want to ask about some of the reporting that or maybe we should go to it right now, that the jury did learn of Judge Rakoff's decision before reaching a verdict. And even though the jurors say it didn't impact their verdict, do you think it's grounds for an appeal?
Yeah, as Joyce mentioned, it didn't take a rocket scientist to know. I think this is a case where a judge has been on the bench for a long time and has probably done this in the past, where I announce my verdict and the jury, of course, won't hear it, and we'll just let them do their thing, and then we'll see how, what they come up with so that there's at least a decision on appeal. But, in 2022, in a case that's as high profile as this, involving Sarah Palin, a former vice presidential candidate, you have to know that this information is very likely to get to the jurors. And so it would have been very easy for him to write his order and seal it, and then wait for the verdict and then share it. But I think he was trying to preempt them, because if they announce their verdict and then he comes out in contradiction of them, it looks much more heavy-handed. And so I think he wanted to preempt their decision. But I think it's bad practice. I think he did it just wrong, and was doing it to kind of save his own reputation. I think that's a bad practice. But nonetheless, is it a basis for appeal, Jill? I think probably not, although I think that there is some fair speculation that could be made that, the jury was inclined to do one thing, and then they saw what the judge said, and, the power of suggestion by a person who is as powerful as the judge. Jurors typically find the judge in the courtroom to be, a very wise person, someone they respect, someone they trust. And so I think it's quite likely that the judge did influence their decision. Now, on appeal, the question will be, there's great deference for findings of fact, as were done here by the judge. It's also the case that it would only be reversed if they found that there was some genuine issue to suggest that the judge got it wrong, and that a jury, if they had not been tainted, would also had come out to a different view. Or there could be a basis to say there was a legal error in one of the jury instructions. Based on everything I've read about it, it is what it really dictated the outcome of this case was this very high legal standard, that she had to satisfy that actual malice standard, and that she just didn't have the evidence to do that. And so I think what's more likely here is that she's trying to use this case as a test case, a vehicle for changing the law. So I don't think the verdict is likely to be changed. If so, the remedy is you get to do the trial again. That's fine. But I think what really is going on here is she wants to push the agenda and say the actual malice standard is too stringent and it should be changed. And there has been some suggestion by some members of the Supreme Court that they have an appetite for revisiting the New York Times versus Sullivan standard and perhaps lowering it to something. So I think that's what this case is all about. It's about getting this legal issue teed up before the courts in hopes of changing that legal opinion.
Okay, so I want to ask about her as a witness, because there was substantial criticism of Sarah Palin's performance as a witness. And it even led to speculation that she wasn't paying for this case, that someone else was paying her legal fees because she would have taken it more seriously if she had. So, Kim, can you talk about why her performance was so poor? What were the grounds alleged for her failure to be a persuasive witness?
Yeah, so in much of the coverage that I saw of her performance, or her testimony, that it was more or less a performance, that she did not seem, not only was she not persuasive, that this reporting had harmed her in some significant way, right? Joyce is right. You have to show that you were harmed by whatever this libel is. It's not, you have to prove damage to one's reputation. She didn't seem to understand that that's what she needed to do. She certainly didn't demonstrate ways that she was harmed. And at times she seemed not even to be taking it seriously. For example, on cross-examination, when it was pointed out that she was able to, go on The Masked Singer as a contestant. So clearly her reputation wasn't harmed enough to prevent her from doing that. When the question was asked, Sarah Palin herself said, "I object," causing laughter in the courtroom. And when asked, why was she acting like her own attorney? She said, "Oh, I was just trying to be funny," right? Well, this is a serious case. So that led to speculation. So I'm going to bring up another case, which is important here. Gawker, if you recall the online publication Gawker, it was shut down by a lawsuit brought by Hulk Hogan. We don't need to get into the facts of that case. It involves Hulk Hogan and a sex tape, and that's all you need to know. But it was later found out, it was a 9-figure judgment against Gawker that resulted in that publication shutting down. And it turned out that Peter Thiel, who is an executive, one of the founders of PayPal, bankrolled that lawsuit because he wanted, ostensibly, Gawker shut down because years before, Gawker printed a post which outed him as gay. Now, Thiel, who later went on to announce at the Republican National Convention that he was proud to be gay, certainly could not bring a libel suit. You would have to show that being called gay is libelous, which I don't think it is. And also, truth is an absolute defense. If he is, that's not a libel claim. But he was still pretty angry about it. And so he bankrolled that lawsuit to end Gawker in a way that is very, that goes against the spirit, certainly, of the First Amendment, if not the letter. Well, the lawyers who represented Hulk Hogan were present at the Palin trial, which led reporters from Politico and elsewhere to ask Palin and others, is Peter Thiel paying for this? They never answered that question. But if that's the idea, is either to bring attention to the New York Times about this, or, as Barb said, to make this a vehicle to try to open up the libel laws, as Donald Trump said, that's important to know, because then this isn't really about Sarah Palin. This is about something much bigger.
So, Joyce, just to follow up on what Barb said, let's talk about what's next for this case in terms of appeal.
Sure. Palin likely appeals to the Court of Appeals, and then if she loses there, which she should, she'll try to get the Supreme Court to hear this case on cert. I think Barb is absolutely right about what's going on here, but I think Palin's strategy is misguided. What she wants to do, or what the people who she's talked with this lawsuit about want to do, is tee up the issue for the Supreme Court of either doing away with the Times versus Sullivan standard or perhaps modifying it. And Justice Thomas has been waging a campaign for the past few years to overturn the actual malice standard. He hasn't been really able to attract anybody else until last year when Neil Gorsuch seemed to jump in with him. The thinking is this: the actual malice standard existed in the day where there was 3 network stations that were giving people news and a couple of big newspapers, and people were thoughtful and careful and they thought-checked before they wrote. Neil Gorsuch says, now that there's all of this stuff out there, people who don't fact-check and all of these media outlets, we need to have a standard that lets public figures recover more easily than the very high standard that actual malice brings into play. So it's entirely likely that Palin wants to tee up her case to change that standard. I'm sure she'd love to have her name attached to undoing that. But the facts in this case are so weak and so bad, I think that this is an unlikely vehicle, even if there are more than 2 justices inclined to take this up.
If you care about the environment like I do, but you still want to keep your house nice and clean, you can get rid of plastic waste and get powerful, effective cleaners for your entire home with Blueland. Their idea is simple and beautiful. Buy the bottle once, refill it forever, no more plastic waste. The only thing you need to discard is your outdated idea that eco-friendly products are more expensive and less effective.
Just fill Blueland's beautiful Instagram-worthy bottles with warm water, pop in one of the hand soap or spray cleaner tablets, and within minutes you have powerful cleaning products in incredible scents like iris agave, lemon, and lavender eucalyptus. From their best-selling Clean Essentials kit to their hand soap duo and plastic-free laundry and dishwasher tablets, Blueland has something for every inch of your home, and you'll feel good about not using as much plastic. And now back by popular demand is Blueland's toilet tablet cleaner. Get it before it sells out again. Blueland's stunning, high-quality Forever bottles start at just $10 when you buy a kit and are meant to be reused forever with money-saving refill tablets that start at just $2. Try Blueland today. If you've got to clean, be smart about it. You'll love it, and the planet will thank you.
And right now, you can get 20% off your first order when you go to blueland.com/sisters. That's 20% off your first order of any Blue Land products at blueland.com/sisters. blueland.com/sisters, or look for the link in our show notes. So there were some dramatic developments this week in the investigation into the Trump Organization and its accounting practices. A judge ruled that the former president, his son Don Jr., and daughter Ivanka must sit for depositions in New York Attorney General Tish James' probe within 21 days. That comes a few days after Trump's longtime accounting firm, Mazars, decided to cut ties with the organization, saying that some documents it prepared should not be relied upon. Also, recall that the Trump Organization's internal accountant, CFO Alan Weisselberg, is under indictment, and Manhattan DA Alvin Bragg's criminal investigation is still live. So where is this all going? Jill, let's start with these depots. Do you think they'll actually happen? Will the Trumps appeal? Will they plead the fifth? What do you expect?
So before I answer your question, I want to also say that in addition to 3 weeks to depositions, the judge also ordered 2 weeks to document production, which is really fast and good. Do I think it will happen? I do think it will happen, but not as fast as any of us would like it to happen, because Trump will appeal, and if it's just for delay, that's probably the only reason he's doing it, because I think he will end up losing, and eventually he will not testify. He will claim the Fifth Amendment if he is forced to actually show up at a deposition. There is legal authority and a factual predicate to justify the investigation and the subpoenas. The defense is arguing that it's just a way to get testimony for the DA's criminal case without going to a grand jury and being forced to give Donald Trump and 2 of his children, who are also part of this subpoena, immunity from prosecution, even though they wouldn't get immunity from civil liability. They would, in New York, get immunity from any criminal case if they appeared before a grand jury. I think it'll happen, and that the evidence will be used by banks for civil claims against the organization, and possibly for criminal prosecution by the DA, and even maybe the Attorney General under the Martin Act. So yes, it's going to happen, but it's going to be delayed.
So, Barb, the statements from Mazars in particular appear to me to be big old pieces of evidence that Donald Trump did exactly what Attorney General James is accusing him of, lying about the value of his assets. How damning is this?
Oh, I agree, Kim. I kind of read it the same way. They basically say, you remember like those financial reports that we submitted for a period of 10 years? Yeah, it turns out we've learned some things, and we no longer say those were reliable. 10 years, you say. And they said, based on allegations we have learned from the Attorney General, as well as our own investigation, we no longer stand by those financial statements. I guess there's 2 ways I could read that. One is that they were unwitting dupes, just like everybody else. Garbage in, garbage out. Now that we've read, one of the key pieces of evidence in this case is that Letitia James filed this very lengthy brief in court in January, where she was demonstrating why she needed to take these depositions. And so she collected all the evidence that she has, or at least part of the evidence that she has. And it was really an overwhelming case, talking about a number of different properties and the really shocking disparities that exist between some of the reported valuations of them. For example, there's one real estate property that was valued at $200 million one year and $400 million the next. Trump represented that the square footage of his apartment at Trump Tower was 10,000 square feet, 30,000 square feet, when in fact it's 10,000 square feet. So things that are pretty objectively verifiable, that look like they're wrong. And so it may be that when all of this information was brought to the attention of Mazars, they said, turns out these all look really troubling, and so we no longer stand by our statements. Or it could be once they read that thing, they thought, oh man, we are all in trouble and it is time to jump ship and distance ourselves from Donald Trump. So we'll see. The facts will prevail and will let us know which of either of those categories is or some other scenario. It reminds me a little bit of the trial against Paul Manafort. You may remember he was Trump's former campaign manager who was charged with and convicted of a number of financial frauds, including misrepresenting his assets to banks so that he could qualify for loans after his work in Ukraine dried up. And one of the key witnesses in that case was his former accountant. And there were a few different people involved in his financial preparations. One of whom said, if I get bad information, I rely on it and I prepare these statements. And so, it's only as good as the information I get. There was another witness who testified with an immunity grant, who said, I got this information and I processed it. And I think for some of these people, sometimes it appears that they may have been acting under what's known as the willful blindness standard. That is, there should have been some red flags that properties don't gain value from $200 to $400 million in 1 year, and apartments don't go from 10,000 square feet to 30,000 square feet in 1 year. And yet business was good, and so they kind of looked the other way and processed this. So I think that'll come out in the end. But nonetheless, this was, I think, probably Trump's security blanket to say, see, my accountant says it's okay, so it's okay. Now that they're gone, that security blanket has been ripped off, and I think the facts are very ugly and have been exposed.
I think the only thing shocking is that it took them so long. I mean, we have known for many years that Trump lies and creates false information. And even if you didn't know before he started running for office, when you could read in the New York Times the falsities, you certainly saw it happening right in front of your eyes, and how anyone could take his statements of valuation without double checking. And when they sign those financial statements, they are basically, yes, they're relying on the information they got from their client, but they have more of a responsibility when they accept the retainer to do some checking and to check the tone at the top. So I think that they're guilty, and maybe they're just cooperating now because it's to protect themselves from criminal liability.
Yeah. So, Joyce, I'd almost forgotten about the ongoing criminal investigation. What liability could the organization be facing and the Trumps themselves? And how are the civil and criminal probes related? That has a lot to do with the fact that we're likely going to see some, if not all, of the Trumps pleading the fifth in these depots, right?
Yeah, the interconnection is really interesting because, of course, the Trump organization is already indicted along with CFO Alan Weisselberg in the case that was brought when Cy Vance was still the DA in Manhattan. Now we have a new district attorney, Alvin Bragg, and his office, frankly, has been very quiet about how the investigation is progressing. That may have something to do with Bragg's background. I think he spent some time as a federal prosecutor, and he's been a little bit more circumspect than his predecessor so far. But there has been reporting that criminal prosecutors in his office have zeroed in on financial documents that Trump used to obtain loans and boast about his wealth, and that they've questioned one of Trump's accountants recently before a grand jury as part of their examination of financial statements. So I think that Jill's assessment of Mazar's role here is right. Their letter saying that they're withdrawing from representing Trump says that they have a non-waivable conflict of interest with Trump. And that suggests that they are cooperating with the New York Attorney General's, at least with the civil case, and potentially with the criminal case too, because what this comes down to is, how did those bad numbers happen? And, Mazars is going to say, it wasn't us. It's what Barb says, garbage in, garbage out. And there will be someone who will be able to say where they got those numbers from. Who provided it? It didn't just show up in the mail one day. There would have had to have been back and forth communications. Accountants always have questions about stuff. Who did they talk to, and who did that person talk to? So the interesting question is obviously whether they can tie any of this to Trump himself, Trump is always the best witness against himself, by the way. And one of the advantages of the aggressive civil case is that Tish James, the New York Attorney General, elicits this written response from Trump in which he testifies against himself. You know, I think it was Barb who said on TV this week that Trump is a nightmare of a client. If I was his lawyer, I would have fired him for making that statement because he really drops the dime on himself. So God bless him. I sort of wish he would zip it. The lawyer part of me thinks, oh, please don't do that to yourself. And then the human being part of me says, oh, keep it up. This is some of the best evidence against you. So all of this evidence, right, is available to prosecutors if there is a criminal indictment down the road. But I have a caveat, and I do wonder what y'all think about this. There are often parallel proceedings where there's a criminal case and a civil case going on at the same time. I had that situation in my old office where I was, in fact, running both of them. And you would often delay the civil case to let the criminal case go forward. And even when that happened in other settings, where I had, for instance, a criminal civil rights prosecution against police officers, but there was also a civil action being brought by a victim, you would either work out a deal or go to court to delay the civil case until the criminal case was concluded. There are a lot of good reasons for letting criminal cases go ahead. There's the statute of limitations. You don't want to have a lot of witness statements floating around there that could interfere or make the criminal case less clear. The burden of proof is higher. And so I have to wonder a little bit about the fact that the civil case is moving ahead so much more quickly than the criminal case appears to be, and if that might signify that prosecutors have run into trouble on the criminal side of this matter, so they're letting the civil case go on.
Yeah, so it will be interesting to see what happens, including what Trump's additional statements are. For those who didn't see it, he was just increasing the amount he said that his company was worth in the billions of by $3 billion in Dr. Evil speak. He just can't help himself. I'm grateful that he is not my client, because that really would be a nightmare.
Bless his heart.
Jill, you know I'm not a big dieter, but I really love the way Noom makes me think about what I eat and what I do. Are you still using Noom?
I am, and it's not a diet. It's a way to approach food as fuel, not as fun, and it really works. It's psychologically terrific, and it's been very effective, and it's made me feel so much better and more able to do exercise and everything else. I love my coach, and I love all the lessons that they teach. What about you, Joyce?
You know, I think the same thing, Jill. I think it's more about retraining your eating habits. And I think I had told y'all I had fallen off the wagon a little bit over the Christmas holidays and just wasn't motivated in January. In fact, I was motivated to bake a whole lot. And so I was trying out new recipes and making cakes and pastries. And I was, of course, eating them. But I found that Noom had given me the ability to eat half of a cupcake and remind myself that that was enough. And now I've gotten serious about it again. And, you know, Noom is a no judgment zone, right? I mean, I just can pick back up and feel good about myself again. What about you, Barb?
You know, I'm a big believer in Noom. I found it to be really life-changing. You know, all those things that you've always known you're supposed to do, like eat vegetables and lean meats and limit sweets and all those kinds of things that I kind of knew in the back of my mind, but didn't really pay a lot of attention to. Turns out when you actually pay attention to it, it can make a world of difference. And so I lost a lot of weight. I feel really fit. I feel really energetic. So I think it's terrific. Noom shows you how to pursue the goals you set for yourself, and it makes you reach them, focusing on motivation and improvement based on science and not the latest fads. No food is off limits. It's about finding your balance. That's the key to progress and success.
The Noom app is easy to use, and if you're like us, you're busy. So I love that Noom lets you be the boss and decide how much time you use it. Over 75% of Noomers end up finishing the program, with more than 60% of users losing 5% or more of body weight in 16 weeks, and 60% of engaged users keep the weight off for a year or more. So get empowered, stay on track with Noom.
Start building better habits for healthier long-term results. Sign up for your trial and get psychology-based support and motivation to reach your goals at noom.com/sistersinlaw. That's noom.com/sistersinlaw to sign up for your trial, or look for the link in our show notes.
So, y'all, right-wing media erupted this week with reports, none of them are true, that Hillary Clinton somehow manufactured a nefarious investigation into the Trump campaign. Because y'all know that Hillary is running again in 2024, right? I mean, that's the Fox News talking point. This all comes out of a case filed by a federal prosecutor, John Durham, against a former DOJ employee, Michael Sussman, who's a lawyer. So, Kim, remind us who John Durham is and what role he's playing at DOJ right now.
Yeah, so John Durham is a former U.S. attorney from Connecticut who was appointed special counsel by former Attorney General Bill Barr to investigate the origins of the Russia investigation, or as the former president said, the oranges of the Russia investigation. If y'all don't know what I'm talking about, Google Trump oranges Russia and watch that video and thank me later. And so this came, Trump made that demand, of course, after the Mueller report, after which he declared that he had been cleared of both charges of obstruction of justice and collusion. Of course, the Mueller report actually had 10 instances of likely obstruction, which led to an impeachment trial. So that wasn't true. But it was very important for Donald Trump that the origins of this investigation be found out. He was convinced that it involved spying and all kinds of broken laws, and Michael Flynn was egging him on. And so Barr appointed John Durham as special counsel to head up this investigation 3 years ago.
You know, it's worth noting that along the way to the indictment of Michael Sussman, John Durham lost his longtime lieutenant and friend, Nora Danahy, who had been a prosecutor in his office in Connecticut and was highly regarded in DOJ. And there's some speculation that the wheels have sort of gone off the wagon in this investigation. So, Jill, talk to us about Michael Sussman, the defendant that John Durham has indicted, and about the charges against him.
It's a fascinating set of circumstances here, because what Durham was supposed to be investigating, of course, was to do with the origins of the Russia investigation, which has panned out to have no cases as a result of his investigation. And he has focused on Michael Sussman, who was a Department of Justice lawyer for 12 years. And then he became a partner at Perkins Coie, which is a very well-known and well-respected law firm, international firm, where he was a cybersecurity lawyer based on his DOJ experience. Although in all these fake reports containing lies, he's identified as Hillary Clinton's lawyer, because that serves the purpose of their narrative. He represented the DNC in a case of Russia hacking the DNC servers. And that's where he came into the public mind. He's been charged with one count of lying about whether, when he went to the FBI's general counsel, who was a friend of his, and reported information that had come from a legitimate investigation that seemed to indicate that there was a connection between a Russian bank and the Trump campaign offices, whether he was acting on behalf of a client, which has nothing to do with the substantive truth of what he reported. And it's not even clear that the facts show that he actually did or didn't do it. It's at most a he said versus he said. And the other question is whether, even if he made this false statement, even if it was false, is it material so that it would be qualified for prosecution under the count that has been brought against him? It's a very long speaking indictment, and it's for one count of false statement, which requires that it be a false statement and that it was material to the investigation. And neither of those facts seems to be correct. And they're making a lot out of this. It's something that if you read any mainstream newspaper, you didn't read about. But if you read any right-wing newspaper or listened to the news, that's where his name came up. And until this event, he was a partner who has been forced to leave the firm until this is resolved, or maybe forever, I don't know. I tried to find out what he's doing right now, and as far as I can tell, he's defending himself in this case.
So we've got an indictment that reads more like a novella than an indictment for charging someone with false statements to the federal government. That's a case that I can indict in half a page, right? It's all above the fold. This isn't a complicated charge. And yet there was this desire to set out extensive, in many cases, irrelevant facts. This is a 5-year-old statement. It wasn't recorded. The defendant denies making it. This is a case that wouldn't have made it out of indictment review in my old office, to be honest. And now we have this pretty unusual motion that Sussman's lawyers have filed to dismiss the case. They're arguing about materiality, which, Jill, you identify as one of the important elements that the government has to prove beyond a reasonable doubt, that it was material, that the statement mattered. Decisions about issues like that are typically left up to juries. But the defense lawyers in this case are asking the judge to decide that as a matter of law, the statement isn't material. Barb, do you think that they're going to succeed, and why are they doing this?
I think it's very likely that this motion will succeed. As you say, Joyce, this indictment would never have made it out of my former office. A false statement can be, as you say, articulated in about half a page. Instead, this one uses 27 pages because the bulk of it is about this whole counter-narrative about how the Hillary Clinton campaign was trying to undermine the Trump campaign. But it fails on the essential element of materiality. I think it may also fail on the falsity of the statement because they can't even pin down exactly what the statement was or whether it was false. The only witness to it is Jim Baker, a name our listeners may remember as the former general counsel at the FBI, who is a straight shooter. And I think he's the only witness, and he's been asked about it. He's like, I don't know what they said. He's testified under oath about it. And he says, I don't really remember. This guy was a lawyer I knew. He came to see me. He provided some information. I said, thanks for the information, and was on my way. And so it was after the fact that Durham, having searched for something to cling to as proof that the origins of the Russia investigation were somehow improper, originally looking at the investigators, the FBI and DOJ, instead found that the FBI was perhaps a victim here and charged Sussman with coming forward on behalf of the Hillary Clinton campaign. But materiality is an essential element of a false statement. That is, even if you say something false to a federal government official, it has to be material. That is important, and it is defined as a statement that has the tendency to influence a matter under consideration. Our friend Chuck Rosenberg has a great analogy that he uses for this. He says, if I'm talking to you and asking you questions that are really important and you're reporting a crime, if you tell me that your favorite flavor of ice cream is vanilla, but in fact, your favorite flavor of ice cream is chocolate, that may be false, but it is not in any way material to our discussion. And so here, the part that they say was material was that he said he was not there on behalf of any client, when in fact they say he was there on behalf of the Hillary Clinton campaign. Now, mind you, they don't say that the substance of the information he provided was false. That is, that there appeared to be Russian banks connected with Trump Tower and the White House, which, by the way, was still in the Obama administration at the time. They never contest that that's false, that the substance of it is false, just that who he was there on behalf. And so, also importantly, what Jim Baker has said under oath while testifying before Congress about this is, it would not have mattered to us if we had known who he was representing, because we at the FBI don't let people vouch for us. We do the work ourselves. We always investigate tips that we think are serious. We would have, and we did, investigate this tip. It isn't the tip that was false, it was the source of the tip. And we don't care who the source is. We do our own vetting, and we did, and we investigated it, and ultimately it did not pan out. But it did not matter to us that it was whether Sussman was there on behalf of a client or not. In that way, I think it will be absolutely impossible for the government to meet its burden to prove this element beyond a reasonable doubt, unanimously to a jury of 12 people. And so for that reason, I think it's very likely that the judge will dismiss this as a matter of law, that there is no evidence to support this claim. As you say, Joyce, ordinarily these are fact questions for a jury, but if there's no evidence from which a rational finder of fact could find guilt, could find this evidence beyond a reasonable doubt, then a judge should dismiss it. And I'm going to predict right here that a judge will.
So that's really interesting. I have a slightly different take on that. I think that the judge may let all the evidence come in at trial and let the government put on its case and then direct a verdict against the government. Because I think you're exactly right when you say there's just no evidence of materiality and maybe even of a false statement here. And this case could be a massive embarrassment for the government. There are even people who've questioned why Merrick Garland signed off on this indictment with a case so weak. But it has caused a furor, Kim, on Fox News and elsewhere on right-wing media. What are they all saying? Is Hillary going to be our next president?
Yeah, it's really interesting. I haven't seen Hillary Clinton in headlines, since maybe 2 weeks ago on Fox News. But they certainly have picked this up, run with this clearly inaccurate narrative that Sussman was working on behalf of Hillary Clinton in an effort to spy on the Trump campaign. It's worth noting that even John Durham in his own paperwork notes that the metadata, it was no spying involved, it was metadata that was involved, came from the Obama administration. Fact schmacks, you don't need those. There's been a constant narrative in conservative media that seized on this little bit. And interesting enough, Hillary Clinton talked about this week in mentioning, we're going back to New York Times v. Sullivan, that this sounds something close to actual malice. It was sort of a veiled threat that if they keep it up, they could be faced with a lawsuit. That caused maybe this to die down a little bit, except for Sean Hannity, who responded by saying, bring it. Now, I hope that the libel lawyers at Fox News are ready to go because they would need to do a lot of work to avoid that if Fox keeps heading down this path. But we may see yet another another lawsuit that we may have to discuss on a future podcast.
We're really coming full circle, right? If you want to tee up the case where the Supreme Court could change the actual malice standard, it would be this one where it actually exists. There has been a big furor, and I noticed that John Durham this morning even filed a statement with the court, or maybe it was a public statement. I haven't looked at it carefully, so I apologize.
Right.
But he seemed to be saying, I didn't mean for this to get blown out of proportion on the media. Jill, Barb, what do you guys make of what's going on here? This is so unseemly for prosecutors to be involved in something like this and to sort of sprung the news into existence. What's happening?
I think it is despicable what's happening, and it has gone really way too far. And it does bring us back to the Judge Rakoff dismissing Sarah Palin's case, saying basically no reasonable jury could ever possibly find in favor of her case because the legal elements are missing. It's the same thing here. It's made up, and as you noted before, the way this indictment of Michael Sussman was drafted was really to portray a narrative that had nothing to do with the case. That was a few paragraphs was all you would need for the actual indictment. So I think it is really, we have to remember that Durham was appointed first to just sort of do a preliminary report investigation kind of thing. And it was only after Trump lost and was soon going to be gone that he was named a special prosecutor so that he would be able to stay on at the Department of Justice after the new administration took over, because otherwise this would have been called off because there was no there. There still has not been, and he's been in office way longer than Mueller was, and there has not been one single indictment that could be possibly linked to the original remit that he had. So I think it's a terrible situation and a shame.
Barb, have you heard about Bloom Nutrition?
Yeah, I have. It is, a great supplement. And I know that Kim and Jill have tried it. Kim, have you enjoyed it?
I really have. I am not the first person, I'll admit, to want to drink my vegetables. But I really do want to make sure that I have a balanced diet and eat enough vegetables every day. We all get busy, and that's something that can easily be forgotten. And so I tried Bloom Nutrition, and it is very tasty. Both my husband and I were surprised at how good it is. And it's easy. It just takes a few seconds and a drink, whether you do it first thing in the morning or for a snack, and you can get the nutrients you need. What about you, Jill?
I am loving it. I just tried it, and I have used it both when I'm really busy in the morning and don't have time to actually sit down and do the thing you should do, which is to have a proper breakfast. That's one of the things that we've all know is true. But if you just mix it either with fruit or something in a blender, or just put it in a glass of water, it's a tasty, low-calorie, healthy way to get your nutrition in the morning. And in the afternoon, when you're sort of flagging your energy and you want to just sit down and get some work done, it's a great pick-me-up. So I'm loving it.
I had some right before we recorded this podcast. And I've noticed that my morning routine can really make or break how my day is going to go. Whether I'm going out for a hike or I'm choosing to hit the snooze button, I make sure I'm going to have my best day every day by starting with Bloom.
I notice you are emitting some sort of superpower, Kim. It must be Bloom.
Bloom Nutrition makes it easy and delicious to give your body what it needs to feel your best, inside and out. Their greens and superfood power blend fight bloating, help digestion, increase natural energy, and keep your skin glowing. Bloom greens are packed with over 50 nutrients, including whole fruits and veggies, fiber, probiotics, antioxidants, and more, all in one easy-to-drink formula. Just mix it with water or a smoothie to add to your daily routine, and it comes in 4 delicious flavors: coconut, mixed berry, citrus, and original.
Bloom is made for you. Whether you're trying to recover from a night out or you're a fitness buff, you'll be joining over 350,000 people who trust Bloom to feel better every day. And right now, Bloom Nutrition is offering our listeners 15% off your purchase of their greens and superfoods blend when you go to bloominu.com. That's BLOOM, letter N, letter U.com/sisters. For 15% off your purchase. That is bloominu.com/sisters for 15% off, or look for the link in our show notes.
Well, now we come to the favorite part of our show. It's where we answer listener questions. If you have a question for us, please email us at sistersinlaw@politicon.com or tweet using hashtag sistersinlaw. If we don't get to your question during the show, please keep an eye on our Twitter feeds throughout the week, where we'll answer as many of your questions as we can. Our first question comes from Sandy in Cleveland, who asks, what do you make of the sentence the judge imposed on Kim Potter? She, of course, is the police officer who was convicted of shooting and killing Daunte Wright when she mistook her firearm for a taser. Joyce, what about you?
So, Judge Chu handed down a sentence of 24 months. The prosecution had asked for 7 years, and she'll have 16 months of that to serve in prison. The judge found that it was within her discretion to, and she did depart downwards. That's how she got to this approximately 2-year figure. The defense lawyers had asked that Kim Potter be sentenced to probation. I think it's a disappointing result. It does little to deter future misconduct by police officers, to prevent them from engaging in this form of extreme recklessness. But what really got to me during this sentencing was the judge's tone, which I thought was so disrespectful to the victim's family in her efforts to lift up the police officer. She made a point of talking ad nauseum about the hundreds of letters she'd received from important people saying Kim Potter was such a good person. And, that's typically true of just about any defendant when they go to sentencing. Most people are good people. And like Kim Potter, they've made a terrible mistake and they deserve to be punished for it. I don't think this judge did her job.
What about you, Jill?
I agree completely with what Joyce is saying. And I also was disturbed by the fact that the judge basically bought in completely to the defense. Oh, this was just a mistake. This wasn't. She was a training officer who should have never agreed to the stop to begin with. And once you get to that point, she set a bad example for the officer she was training, and now for every officer anywhere in the United States who sees that the consequences are not nothing. I mean, she will serve several more months. She's credited for the time already served, and it will come down to just a few months more in jail, and that seems completely wrong. If she was at least forced to serve at least the full amount of the sentence, I would feel better about it, but I agree with Joyce that this was not a fair sentence.
What about you, Kim?
It's really interesting. So today, there was a lot of wind on the East Coast, as some of y'all know, and a power line got knocked out near my house, and so the street was closed off. As I was awakening, there were police cars all up and down the street to close off traffic, so that traffic obviously wouldn't get anywhere near this live wire. And despite the fact that I understood that that's the job of police officers, and I was very glad that they were there because I didn't want anybody to get hurt. My viscera had a very different reaction. I had some errands I was going to run this morning, and I chose not to because I really did not want to walk past a bunch of police cars and police officers, regardless of what they were there for. And that feeling surprised me. And I realized it's like, wow, you know what? The past few years of all the images that we've seen of police brutality, all the stories that we've heard about it, even if it wasn't caught on tape, George Floyd, Breonna Taylor, Sandra Bland, all the people who are not here, that has had a traumatizing effect in a way that I didn't even realize. Even when I know police are there for good, I don't want to have an interaction with them. And I didn't even realize that today was the sentencing for Kim Potter. I turned on the TV and there it was. And all I can think about is that we need, as a society, to make such fundamental changes about how policing is done, what the impact is on the community. And I think we need to hold all the people, whether or not they've had interactions. I've never been handcuffed. I've been stopped in ways that was terrifying by a police officer. But even having not being handcuffed or facing a gun, it's still traumatizing. And all I can think of today are the members of the Wright family who testified today, including the mother of Dante Wright's son, Dante Jr. She testified about how the baby was born premature and had to be in the NICU for months. And just thinking about that, thinking about how difficult young motherhood has already been for her, and now the father of her son is dead. There's a lot of trauma in the nation and in that family, and that's what I'm thinking of today.
Yeah, the conviction of Kim Potter, I thought, was an important moment for accountability when police officers use violence against unarmed Black motorists. But it feels a little bit like all that good has been undone by giving her what I see as kind of a slap on the wrist of a sentence here that does not fully reflect the seriousness of the harm.
Could I just add one thing, which is we often hear about jury nullification, that sometimes a jury will acquit because of reasons that have nothing to do with the law or the facts, but some other element. This is almost like judicial nullification, because even if she bought into the defense, the jury didn't. They convicted her, and she was sentencing for the crime that Kim Potter was convicted of, and she didn't do that. So I just feel like this is really a wrong sentence.
Our next question comes from Don from Sea Ranch, California. And Don asks, how can local and state governments legally ban books? I think the answer, Don, is that it's not the governments that are banning them from everybody. It's these school boards that are charged with selecting what they believe to be appropriate materials, learning materials for students of particular ages. And so I think in that way, that is how they are, quote unquote, banning books. They're not, eliminating them from access in the state, but they're making it so that kids can't read these books when they're in school. They won't be assigned reading. But that makes me wonder, sisters, about your own reading. There are all these lists out there of famous banned books. Wondering what are your favorite banned books? Give me one. Joyce, what's your favorite banned book?
Well, I know because we've talked about it that Jill and I have the same one. I've actually got Mouse sitting behind me on my desk. It's a graphic novel written by the son of a Holocaust survivor. And of course, in the spate of rising anti-Semitism, of course, Mouse makes the list of books that get banned, right?
And I have the benefit of someone on Twitter having seen that I had tried to order both volumes of Mouse, and it's sold out. And
Oh, wow.
they are sending me their copy of it so that I can read it. So I am very, touched by that. And I also have a T-shirt that says, I read banned books. And I think no book should be banned. I think that it's up to parents to say, I don't want you to read this, and here's why, or to explain what the real meaning of a book is. But no book should be banned from a library. That's how we get to authoritarian dictatorships and terrible outcomes. And the list is so long of banned books that it's frightening to me.
Well, Jill, they're not going to know that because they're going to ban 1984. So they're not going to see what happens when you ban the books. So
There's a course offered at Michigan Law School by some First Amendment scholars and the Chief Justice of our Michigan Supreme Court called Reading Banned Books for Credit, which I love. And exploring these concepts. Yeah, isn't it great? Kim, what's your favorite?
Let's publish the curriculum from that on our show notes.
Yes. Kim, what is your favorite banned book?
I was going to say Beloved by Toni Morrison, but I'm just going to broaden and say all the books by Black people that are getting banned right now, because there are a bunch of them.
Yeah, if you look at the list, it is an enormous percentage of all the books on the list. All right.
It really is my goal to go through and read or reread all of the books that are getting banned. If somebody wants to ban them, you know that they've got to be worthwhile.
Yeah, well, if you look at these books that have been banned historically, there are a lot of classics, like The Grapes of Wrath is on the list. Catcher in the Rye is on the list. Even the Harry Potter series is on the list. But I think I'm going to go with To Kill a Mockingbird, A Lawyer's Favorite. That one's on the list, and I'm going to go with that one. So that's all we have for now. But listeners, we'd love to hear your favorite banned books, too. So put them on our reading list for us. We'd love to hear those. Thanks for listening to #Sisters-in-Law with Kimberly Atkins Storr, Jill Wine-Banks, Joyce Vance, and me, Barb McQuaid. You can send in your questions by email to sistersinlaw@politicon.com or tweet them for next week's show using #Sisters-in-Law. And you can go to politicon.com/merch to snag our new women's tee. It's terrific. It comes in a beautiful pale blue. We're all excited about it. We've all got our women's tea sisters-in-law shirts. So I hope you'll join us in solidarity in wearing them just in time for spring. And please support this week's sponsors, HelloFresh, Noom, Blue Land, and Bloom Nutrition. You can find their links in the show notes. Please support them as they really help make this show happen. To keep up with us every week, follow #Sisters-in-Law on Apple Podcasts or wherever you listen. And please give us a 5-star review. It really helps others to find the show. See you next week with another episode, #Sisters-in-Law.
Y'all, I do have to tell you that my husband, we both used to do defamation work. He did a lot of work, and at one point they were representing Penthouse, and it was before he was my husband. And I flew down and walked into his office unexpectedly on a Friday afternoon, and he had Penthouse magazines, a bunch of them, spread out all over his desk. And it's classic. Bob is like 6'2", so his feet are up on his old desk, and he's reading a Playboy. And I walk in, and I'm just laughing at him. And his senior partner, who's this lovely man, Jim Barton, who's in his 70s, the epitome of a Southern gentleman, except that he was super liberal. And Jim walks in and he looks at Bob, he looks at the penthouses, and he looks at me and he says, "I swear to God it's work related."
That's
He was
funny.
so quick. He didn't want Bob to get in trouble.
That's so great.
So in the category of there's nothing I haven't done, I get a call. I get a call that I'm in Penthouse magazine, and I freak
That's
out.
new.
This is during Watergate.
Oh, no.
And I
Oh, no.
run
Penthouse
over
pinup.
to
Who knew?
I run to a newsstand that's far enough away from the office, but it's actually right near the White House, right around the corner from the Willard Hotel. And in typical stupid fashion, I pick up Penthouse and I pick up Time magazine and cover the Penthouse with it. And I walk over to the cashier, who takes a look at it and says, "You want a brown paper bag, lady?" I'm like, I turn red and "Yes, please." And I leave the magazine store and I go back to my office, shut the door, and I look, and there's no photo. There is a comparison of me to Rosemary Woods, just sort of our backgrounds and our heights or something, but there's no pictures. So I'm hugely relieved that it wasn't what I thought it was.
Some people buy it for the articles, too.
Is it
Well,
true there's an
I-
item
you know-
on your resume that says once appeared in Penthouse magazine?
No, it's not in my resume.
Jill would
but-
be the ultimate champion of the
anyway.
game. Never have I ever.
Yeah,
no,
there's
she would
nothing,
end up
there's nothing
drunk
left.
because she's
There's
done
nothing on the list.